Hello and welcome to the European Resilience Initiative Center video podcast. Today our guest is Yuliya Ziskina. She is a senior legal fellow for Razom for Ukraine, a US-based NGO which provides humanitarian aid for Ukraine and supports Ukraine. Welcome, Yuliya.
Thank you. I'm happy to be here.
Yuliya, you are a legal expert and you are working a lot with the topic of seizing of Russian sovereign assets. What assets are we talking about?
So I'll give you some background explanation just to frame our discussion today. So here we're talking about the frozen assets of the Russian central bank. In other words, the state or sovereign assets of the Russian Federation. We're not talking about the private or oligarch assets, which are dealt with a little bit differently under the law. So just to get into a little bit more detail, the central bank and other central banks besides Russia hold their assets in foreign currency in order to manage foreign exchange transactions. And the vast majority of these assets are held in the form of securities. So securities are bonds. They're basically promises to pay that are issued by governments. So central banks basically hold each other's governments' promises to pay, or they put money on deposit with one another. And it's basically a sort of web of mutual commitments. So these are your typical central bank reserves. They're essentially money that governments keep safe with other countries until they need it. And when we're talking about the Russian frozen assets, there's about 300 billion of them frozen in Western countries worldwide. Most of the amount is in Euroclear. Euroclear reported that it holds about 190 billion euro of the total 300 or 350 billion is the estimate. And Euroclear is a clearinghouse that's located in Belgium, but it manages the holdings of other governments. So other governments, through their correspondent banks, often hold specific currency denominations in Euroclear. And I want to stress that, and this is important, because there's actually an argument to be made that these other countries actually have jurisdiction over their currency-denominated holdings in Euroclear. So when we say 190 billion is in Euroclear, that's only half of the story, because other governments probably have jurisdiction over that amount. The other amounts are scattered around other G7 countries, like the US, UK, Japan, Switzerland, and Canada. We don't really know the exact amounts because governments haven't released that information. The best sources of information that we have to piece together the amounts are public statements from the Russian central bank itself, but the last time that it reported on the holdings was prior to the full-scale invasion, so that information probably isn't quite so accurate anymore, or ever, and public statements from various government officials. So it's a bit of a piece of a puzzle. But I will say that providing greater transparency about the amounts and locations of immobilized state assets would actually be a very crucial step towards confiscating those assets. It would also enable us to have a better understanding of how much and where the missing or yet undetected assets are and how they can be best targeted. So this is also something that governments must do as a crucial first step.
That is a lot of information you have already provided with this your first answer, and I have heard the sweet word confiscation, because freezing is one thing, confiscating is another thing, and we have heard many times that it is impossible under international law to confiscate other states' sovereign property because it would be a violation of sovereignty principle, but isn't it already proven that when we can freeze them, it is already a decision which we have taken over other states' sovereign assets? So we can go just one step further and say, okay, we have frozen it, we can confiscate it. So what does really international law say about this?
That's a great question, and you are completely correct that freezing the assets in and of themselves was against international law, and I will explain why that is. So there is no doubt. So let me just backtrack and lay the fundamentals. There's no doubt. Let's start with that about the illegality of Russia's invasion of Ukraine and the occupation of Ukrainian territory. By doing this, Russia has violated the most fundamental rules of international law that are in the UN Charter, which prohibit the use of force against the territorial integrity and political independence of another state. That is so fundamental. And this fact has been recognized not just by the United Nations in repeated resolutions, but also by the International Court of Justice, which ordered Russia in a binding ruling back in March 2022 to desist its aggression, which it didn't. So there's legal recognition that Russia is waging a war of aggression. That is not disputed in the Western world. It's also not disputed that under international law, Russia owes reparations for the damages that it has caused by waging this war of aggression. So Russia has violated two obligations, the aggression itself and the duty to pay reparations. So in the face of such a blatant violation of a state's international legal obligations, such as that Russia has committed, international law permits other states to respond with what's called countermeasures. The basic idea is that countermeasures are a self-help tool to enforce international obligations in situations exactly like this, where institutions, for example, the UN Security Council, have failed or they're defunct. What are countermeasures? Countermeasures are delineated by the UN International Law Commission's articles on the responsibility of states. These articles represent the most authoritative statement of customary international law on state responsibility. That they are the most authoritative statement that we have. They're frequently cited by the judgments of the International Court of Justice and other international tribunals. So they're the best statement that we have. Countermeasures are defined in these articles by definition as state acts that would ordinarily be wrongful, such as interfering with sovereign property. But the wrongfulness of that act is precluded because the action is taken against another state for its serious violation of international law. So what did I mean by asset freezes were wrongful acts? Well, typically, countries can't interfere with each other's property, and that includes freezing their assets. So asset freezes and asset seizures are both examples of countermeasures. So in this case, by transferring assets to an international compensation mechanism, or seizing them and then transferring them, states would cause Russia to comply with its obligation to make reparations to Ukraine. And that in and of itself would be a lawful countermeasure. I also want to bring up the point, and I think it's worth pointing out, that states have a positive duty, a duty to act, in other words, in accordance with Article 41 of the RCWA, which says states shall cooperate to bring an end through lawful means any serious breach. They shall cooperate. This means that third-party states aren't only entitled to take countermeasures, they actually have a duty to do so. Ukraine is obviously entitled to take countermeasures because it was directly affected, and third-party states can as well. When a country's misconduct is so egregious, such as Russia's, that it violates the very core norms of international law, it's considered to affect the entire global community, and any state therefore has the right to take countermeasures against it. So just to put it in very simple terms, the idea is that no country can have it both ways. Aggressors can't violate every single tenet of the rule of law and then use it to claim protection for their property. That is countermeasures in a nutshell, and this is what international law says. So when people say, well, this would be an exception to international law, actually, no, it's not. It is international law.
So if I understand you correctly, these articles you're talking about, if I'm not mistaken, they clearly cite that they describe unlawful acts, which are in normal situation, you cannot do it. You cannot bomb another country's territory, but you can do it if that country has attacked you and you are in absolutely fair or defensive war. Or you cannot kill other people, other nation soldiers, but you can do if these people are invading soldiers who are on your ground. The same you can do with the property. Normally you cannot freeze it or confiscate it, but in a case of the aggression, you may do it because these wrongful countermeasures are countermeasures. But what I wanted to ask you, if I'm not mistaken, that in these articles they only are applicable as long as the United States Security Council has not spoken. And in this case, it is what we have. But Are these articles, as you say, are they binding for other nations? So can we say that other nations must confiscate Russia's assets, or is it what they may do not, depending on their political mood?
So first point I do want to clarify is that they're not just applicable when the UN Security Council has failed to act. They are not mutually exclusive. They're meant to operate in addition to the mechanisms of the UN Security Council. And that's because countermeasures are intended to be decentralized relations between countries. So any country or group of countries can participate in collective countermeasures, even if the UN Security Council has taken action. So that doesn't preclude it. What the articles do is that they basically govern relations between states, and any state can choose their relations to another country. So I just wanted to clarify that point, that they're not mutually exclusive. But in this case, they are even more important because the UN Security Council has failed its mission to bring about peace and to bring about stability in the world order. So our last form of enforcement really is countermeasures. But to your second question, I believe what the articles themselves say under Article 41, it says that states shall take action to bring about the lawful means of an end of a breach of peace. Shall usually in legal terms means a mandate. It means that they must cooperate and they must do this. However, the thing with international law is that it's not black letter law necessarily, it's customary international law. So it's determined by what countries view it as. So they may choose to abide by it, they may not, they may have a different view of it. So in practice, while it says that states shall cooperate to bring about an end to this aggression, the reality is that different countries have different views of it, and it's more a political decision than it is a legal one. And that's really at the heart of this whole issue.
How much is the possible actions of national states, sovereign states, dependent on their domestic law? I can imagine a situation when the international law allows or even encourages the countries to act, but their domestic law doesn't foresee any procedure or even bans states from doing that. What is the legal situation in, let me say, the G7 countries?
So sure, I mean, but I will say to begin with, each country will obviously necessarily have its own laws and its own legal system. That's pretty obvious. But I would say that the principles are generally the same in most Western countries that follow Western principles. I think the best way to perhaps explain this question is to talk about one of the main misconceptions, and I think that it's one that you brought up a little bit earlier. One of the main misconceptions, and one that the audience has probably heard, is that Russian state assets are protected by domestic sovereign immunity laws, and that seizing those assets would deprive Russia of due process under that whatever country's constitutional legal system. So that's the main obstacle that people usually cite as a barrier under domestic law. But I do want to clarify that, because that is a misconception. And that's because sovereign immunity and due process don't apply here. There's no immunity between sovereigns. What there is instead is state responsibility. This is what I alluded to with the articles, and that's what's laid out by the UN International Law Commission. Sovereign immunity, though, only shields a state from actions by foreign courts. And due process is a court-centric doctrine. Sovereign countries don't get due process under domestic laws because they're not a person, and their sovereign property is not the same as private property. So it's governed by two different sets of principles. So under domestic law, by transferring assets using executive action, sovereign immunity doesn't come into play. So what do I mean by that? Under domestic law, the countermeasures would be adopted and implemented strictly by the executive branch of government, or the legislative branch. In other words, the political branch of government, but not the courts. This would be a decision by the legislature or cabinet decisions in a parliamentary system. Some countries already have laws in place that could be used for something like this. For example, I'm from the US, so I can speak to US law. In the US, the president could, for example, issue an executive order. And this would be authorized under the International Emergency Economic Powers Act. But some countries don't have an analogous law like that, obviously. But that's the thing. That's the job of lawmakers. The job of lawmakers is to make the law. If a law doesn't exist to do a certain thing, then the lawmakers can draft that law. So to the extent that a country's current laws make it difficult to use Russia's sovereign assets to pay for the destruction that it has caused in Ukraine, lawmakers should work to change the law. It is that simple. Instead, but for governments to throw their hands up because the law as it currently is difficult, or it doesn't exist, or it prevents them from doing anything more, when it's them who make the law, I would say that that's a dereliction of duty. So to the audience, please don't let arguments that, oh, our domestic law just doesn't allow us to do this, stop necessary discussion, because the law evolves and the law changes, and this is what lawmakers are elected to do.
Absolutely. I can imagine that in the European Union it could be a bit more complicated, because part of national member states' sovereignty has been transferred to the European Union. And here we can say, okay, like even our sanctions politics is binded to the WTO law and to the UN law, which we see in the text of the treaty and in all like documents which govern our sanctions policy. But still, we can act as sovereigns, which we still are. I mean, the states and security issues are still in foreign policy, still in the hands of the national governments, despite the common security and foreign policy of the European Union. And what I wanted to ask you, if the G7 countries altogether, or one by one, confiscate Russia's sovereign assets, what are theoretically Russia's legal options to oppose it? Of course, Russia will threaten with nukes, what they always do, but what are the options besides of that?
Well, like you said, Russia can threaten whatever it wants to threaten. As we know, it has threatened a lot of things, but they haven't come to fruition. For example, it's threatened nukes when the U.S. provided HIMARS, it's threatened nukes when it's provided javelins and ATACMS and all sorts of things. But we can't let that be a self-deterrent. We can't let Putin, who is basically one overgrown toddler throwing a tantrum, dictate our own foreign policy. So that I will say that at the outset. But in terms of what Russia can do legally, apart from a threat, very little. It's very unlikely that Russia can effectively legally oppose this. And that's because there's no international court that would presently have jurisdiction. Russia doesn't accept the jurisdiction of the ICJ. It doesn't accept the jurisdiction of the European Court of Human Rights or any other international court that would be suited to hear this dispute if states were to seize and transfer assets. In theory, let's play this out. In theory, Russia could choose to submit itself to the jurisdiction of the ICJ. They could say, okay, we want you to hear this case. But the fact is, the ICJ has an open case against Russia, where Russia is in continuing breach of a clear order of the ICJ to suspend its military operations in Ukraine. So let's think how this would play out. So, I mean, if a state were to repurpose Russia's assets, that measure would be clearly aimed at enforcing Russia's legal obligations to Ukraine and the rest of the international community to stop waging that illegal war and to compensate for the damage. That would be the purpose for those countermeasures. So by bringing a claim in the court whose orders that Russia itself has disregarded, Russia would need to explain to the ICJ why it has failed to comply with the orders of that court. And because its failure to comply with the orders directly led to the countermeasures in the first place, that would actually strengthen the lawfulness of the countermeasures by showing that its conduct was illegal. It would open itself up to that counterclaim. Russia knows that. I don't think it would. It's not stupid. So I don't think it would willingly open itself up to that situation. The other place, theoretically, Russia could sue in the national courts of the state that confiscated its reserves. So say it could hypothetically, sue in the Southern District of New York if the US went and seized its reserves. But it's also unlikely to do that because it would be waiving its sovereign immunity. It itself would be bringing a case in a foreign court. And it's not in its interests to litigate in a Western country's courts, especially one that has placed historic sanctions on it. Can you imagine a situation where there is a US versus Russia court case happening in the Southern District of New York? That would be very interesting to see. So that's kind of, I think, how that would play out. But I guess the other point is that a bigger picture, the states that are seizing the Russian assets in their jurisdictions wouldn't be taking those assets for their own enrichment. They're not taking them to build roads in their countries or for their own citizens, but they'll be taking them for the purpose of compensating the victims with the money, the Ukrainian victims, with the money that Russia already legally owes. So Russia is unlikely to show that that kind of confiscation is unreasonable or unjustified, or that the countermeasures were unlawful. It's a very strong case. So even if Russia brought suit in the ICJ or in national courts or a tribunal of some sort, it would be very unlikely to win it. So we need to be looking at not just whether Russia will bring a suit, but how likely it is to win.
Absolutely. But as you have described, that the chances that Russia sues other countries or international organizations for having frozen and confiscated its assets, the chances are very low. Despite that, we have seen recently the decision in the EU to keep the profits from the frozen Russian assets as a guarantee for payment for future legal procedure between Russia and, let me say, the EU, to pay the fees for the court or pay the legal firms. Is such decision to keep the profits from the these frozen assets, is it clever? And what is the debate between this division between the frozen assets and frozen profits from the frozen assets?
So there's two parts to that question. Let me first. So I think when we first start by talking about the windfall tax proposal, I think this is what you mean. This is the recent decision by the EU to keep the profits on the frozen assets. So these assets are sitting there in Euroclear, and in the past 2 years they have been accumulating profits. The EU recently made the decision to provide those future profits to Ukraine, which amounts to about $3 billion a year. So let me talk about this proposal as a whole, and to step back a little bit. In the beginning of this whole discussion, about 2022, early 2023, there were some well-meaning but mistaken international law professors who put forth the opinion that sovereign immunity basically means that you can't touch Russia's money. And this was because of mistaken views in international law, or from professors in international law who were professors but don't necessarily practice before the courts. Those misconceptions have been cleared up, kind of as I explained earlier in regards to sovereign immunity, but unfortunately they've tended to linger among governments. And this has led to a bit of a wild goose chase towards various alternatives, like the windfall tax, or the windfall proposal. So this windfall proposal arose in about spring 2023 as a way to potentially get some money to Ukraine without taking up the issue of countermeasures, because governments are resistant to taking up that doctrine. And this is how it works. The idea is that once the assets have matured into cash, Euroclear reinvests them, and the profits from the reinvestment of those funds under Belgian law is regarded as being Euroclear's property, not Russia's property. This is a little bit odd because most lawyers would tell you that if you own the principal amount of the money, then you also own the proceeds of that. However, that's not Belgium's view. So their view is that Euroclear is the owner of the profits. It is what it is. It's a bit odd, but that's their legal argument.
So practically, the Euroclear has already confiscated part of Russia's sovereign assets in form of profit that had been generated by this asset?
So that's what we would think, and I think that's what the view has been, but apparently not under Belgian law. No, under Belgian law, Euroclear is the owner of those additional profits. However, the problem with this proposal is that, Euroclear is the owner of them, and this proposal doesn't apply retroactively. So the profits that Euroclear has already earned in 2022 and 2023 remain with Euroclear. And this proposal only applies to future profits. So what about the 5.2 billion that Euroclear has earned between 2022 and 2023? Where does that go? No one has provided an answer to that, but essentially that money stays with Euroclear. And that money is 10 times the amount that Euroclear has earned in previous years, if it weren't for freezing those assets as a result of the invasion. So by not giving that money to Ukraine, Euroclear is essentially becoming a war profiteer. It is getting money from the frozen assets that wouldn't have been frozen if not for Russia's illegal invasion. That money goes to Euroclear now. The only way for Euroclear and the Belgian government and the EU in general is to get around this reality is to invoke countermeasures to seize that money, which morally and rightfully belongs to Ukraine. So that's the issue there. Obviously, that's not in Euroclear's interests because it's making a huge profit. Why would it want to give that money up when it could go to their shareholders? So there needs to be more pressure on this. There needs to be more discussion, and this needs to be more of a public fact.
What you are describing now, it seems like it is not one question which is not being decided. It is the number of questions is growing, and we don't have a single answer to any of them. So while the war goes on, we don't have answer what to do with assets, what to do with profits, what to do with profits over the profits. And is there any way to come to any single solution? And if not, why?
Well, really, this comes down to a matter of political will. And what's been happening so far is, first of all, lack of political will and the misconception that these assets will remain frozen until the end of the war, whenever that is, whatever that's going to look like. But that's not necessarily true. There needs to be more of a sense of urgency because Ukraine needs these funds. These funds could be unlocked to help change the outcome of the war. So it's a false sense of time, which we don't have that kind of time. And it's also a false sense of who's going to be the first country to act. The G7 has been looking around to everybody else to take the lead. And saying, well, we'll see what happens, but without taking any kind of real commitment. But the decision needs to be made, at least by one country, to implement the domestic law for the seizure of Russian state assets. And I believe that everything else from that will follow. One country needs to be brave enough and willing to put its legislative action where its rhetoric is.
What country could it be?
Excuse me?
What country could it be?
Well, I think Canada is in the best position to do this, honestly. And Canada has probably taken the most action towards it, and it is most likely to do it. And it's less risky for Canada as well, because the amount of frozen reserves in Canada is a negligible amount. So what it could do is provide a model for the rest of the G7 to then follow. There's been so many discussions about we need to move unilaterally, we need to make this decision together. And yes, that is absolutely true. But we are stuck in a cycle where everyone is waiting for the first person. Somebody needs to be that first one, and then that will unlock the rest.
And what is the position of countries outside of Europe who belong to G7, for example, but not only? They're not affected directly by this war, but they maybe don't have like a lot of Russian sovereign assets, but they still have their role in the international politics and economy.
So outside of the G7, they don't hold Russian sovereign assets, unfortunately. So a good example of that is Estonia. Estonia is hugely supportive of asset confiscation, and it has even started drafting a law to permit the confiscation of assets. However, its position is that it does support confiscation of state assets, but it just doesn't have Russian state assets in its jurisdiction, so it's limited to private assets. So other countries, say, for example, in the global south, are opposed to it for various political reasons, but frankly, they don't have Russian assets in their jurisdictions, so they would be unable to join into those countermeasures just by the fact of not having assets.
But what about countries like Japan or South Korea? Japan is a G7 country, South Korea is not, or Australia or other countries which have significant economic role. Do they have Russian sovereign assets in their jurisdiction?
Yes. So Japan has about 20 billion. Japan is also a huge player in this, and I don't believe that they've made a public statement about whether or not they support asset seizure. So I'm not really sure what the official position of the Japanese government is. But I will say that Japan is a strong ally to Ukraine, and it has been in line with the rest of the G7 on imposing sanctions and asset freezes. So I think it falls into that same category of, if the G7 moves on this, then Japan would also likely move with it. And that's just the general sense that I've gotten. I'm not sure about South Korea. I don't believe it holds any Russian state assets. I'm fairly sure that it doesn't.
So what are the next steps which are to be expected? Can we expect like some sort of a commission or a round table, like something economic Rammstein, dealing with the seizing of Russia's sovereign assets? Or will it continue to go this low-fire discussion with everyone is afraid of the consequences and doing nothing?
It's hard to say. Unfortunately, I can't predict the future. But we'll say that the Ukrainian government and the Council of Europe have together established the Register of Damage. It's based in The Hague, and right now it's an accounting of all of the damage that Russia has committed in Ukraine. It's intended to first be a documentation of that damage, but then from there it will be a claims commission. So injured parties can submit claims, and from that fund, the fund being eventually the confiscated assets, those claims can be paid out. So this is already in the process of being established. They're opening up the Register of Damages, opening it up for claims on April 2nd. So very soon, people can start submitting documentation and can start submitting their claims. So I think this is an incentive for governments to not just sit around talking, because otherwise you're going to have millions of people and millions of businesses who have submitted documentation in hopes of receiving reparations or some sort of justice, but without any money to pay them out. So this is an incentive to actually start doing this. And I think it's a very good idea on the part of the Council of Europe and Ukraine to start building the mechanism. Once you start building the mechanism, that provides an incentive and it provides pressure and a push for governments to finally make a difficult decision that they've been prolonging and kicking the can down the road. We can't let them keep kicking the can down the road. This question is not going to go away. But the longer that it lingers and the longer that we prolong it, the more harm that does to Ukraine and the more harm to Russia's victims and the more harm to Ukraine ultimately potentially even losing this war, because it doesn't have this huge pot of money that it can use for reconstruction or even for military. In terms of the sense of urgency that I touched on earlier, I think this is very applicable here. This really needs to happen soon. I think in the next few months there needs to be some kind of solid, concrete decision. And this is because there's a prospect of Donald Trump returning to the White House. I'm going to be very clear about that as an American. That's a scary possibility, but it could be true. And if he returns to the White House, this casts doubt on the future of US support for Ukraine. And this could be the difference between victory and defeat for Ukraine. So
Absolutely.
seizing the central bank reserves for Ukraine, if we do this before the US elections or start of the next administration, God forbid if Trump wins the election, this would be $300 billion worth of Trump insurance. We have a pot of money that we can use even if Trump decides to stop sending money. But the only way that this can happen is if the US and its partners start acting together, and somebody needs to take that first step.
Absolutely, and that is what you have already described. We need a mechanism, a tool, but we need also political will and strategic foresight, how to act, what we want to achieve, and what are our goals, and how can we come to our goals. It was Yuliya Ziskina, who is a senior legal fellow for Razom for Ukraine, a US-based NGO which provides humanitarian aid for Ukraine and supports Ukraine. Thank you, Yuliya, for this insightful interview.
You're very welcome. Thanks for having me.
Thank you once again, and don't forget to like, to share, to subscribe to this channel, and wait for the new interviews.